Good morning. Welcome to Law Power Hour. I can't believe it's June already. It seems like the days are flying by in the calendar. It's a little cooler, but a great day to be out and enjoy yourself in Detroit. Amel Knox, thanks for coming.
I am so happy to be here, Attorney Keller. It's my pleasure.
Amel is a specialist in disability law. She has a wonderful, wonderful background. University of Michigan, Valparaiso. She's worked on disability from the time she left law school up to the time she came on to this show this morning.
Thank you so much. So, I started off as a disability examiner.
I want you to
Oh,
explain
I'm
to our
sorry.
audience, that's okay. Explain to our audience what a disability examiner is.
So, a disability examiner is someone who's working with the state because it's a state and federal program, and they are adjudicating the claims. They are the first eyes that see your disability claims and your Title 16 and Title 2 claims.
Now, I asked you before the show whether an individual who's applied for Social Security under Title II, which means that they have a wage earning background, or Title 16 and they haven't the credits, which we'll talk about a little later, can apply under the state to receive disability benefits while their case is pending. Can that be done?
Yes, it can be done, and a lot of people don't know about that. Actually, my mom went through that process because she had cancer, but hers did not metastasize, and so rightfully so, her claim was denied.
Okay, I want you, and I hate to say this, I want you to listen up and listen carefully, because I want you to tell all your friends about this. There is a fund through the state that you can receive and you can apply for benefits, correct?
That is correct.
What's the process?
The process is you likely need to contact the Michigan Department of Community Health. If you call them, they should be able to get you in touch with a caseworker, and at that point you'll let them know what your condition is, and they can fund you to or funnel you to the right department to respond to.
And do you have to file an application similar to the application you have to file for Social Security disability?
It is a very similar process. They also have ALJs or officers, adjudicative officers, who will review the claim if it gets to that point. But a lot of times, if you properly document your application, you don't have to get to that level.
So you can have parallel claims. In other words, you can have a claim at the federal level and the state level pending at the same time.
Absolutely. And a lot of people don't know that. And one of the important things is that Social Security disability, it is not an immediate measure, but it's for people who you can't go to work again. You really need to not be working, even though a lot of people, they kind of have to, they're in a rock and a hard place. They have to do what they need to do. But it just makes it that much more fluid of a process if you're not working at all.
Now, let me explain to you exactly what Amel said. I had a client call me the other day, and he has stage 3 cancer. And I told him in order to qualify for Social Security, he has to be off at least 6 months before he can apply, because he has to have a disability that lasted or will last how long?
For 12 months or longer.
However, if he applied for state benefits and he received some subsistence, it's not going to be great, but it's going to at least keep the wolf away from the door. And if you get on state benefits, if you owe money for child support or you owe money for tickets, that's your card that'll stop the process while you're going forward, because you can take it into court, you can take it in to the friend of the court, and they'll understand, they'll hold off enforcing the claims while your disability claim is pending, correct?
That is correct, and that also usually strengthens your federal claim, because at that stage you would have possibly your own physician, your treating physician, write a medical source statement on your behalf explaining what your major diagnosis is. At that time you would also likely have diagnostic testing.
Now, Amel has used a term that is familiar to me but not familiar to our audience, a medical source statement. Do you know why most individuals lose Social Security disability cases?
No, actually. Is it because of lack of medical source statement?
Yes. In other words, it's because their doctors do not take the time to write a detailed explanation of why a person's disabled. Willy-nilly, and I'm not picking on the medical profession, they'll put down a diagnosis and a prognosis. In other words, they'll say that somebody has a ruptured disc in their neck, a ruptured disc in their back, and they'll use the term sciatica, which means that they've got pain running down their leg, but they won't take the time to explain how this
impacts them on a daily basis, how it impacts the client, how it affects their ability or their lack of ability to do or complete certain tasks. I'll give you an example, which I know you're very familiar with. I've had a client in the past, she had carpal tunnel in her right hand.
Okay, what's that mean, carpal tunnel?
Carpal tunnel means that her nerves are not functioning properly in her hand. It's difficult for her to grip and grasp things, and she has difficulty with fine and gross manipulation. So maybe she'll pick up some keys and she'll drop them because she thinks she has them, but she doesn't.
She can't hold a coffee cup.
No, and so she was dropping dishes. And let's say her last job was at a factory. She had to install, let's just say, a peg into a hole. And she's not able to do that because she can't pick up that small of an item. Maybe she can write her name for a moment, but after gripping something for so long, her hand is in pain and she's in severe pain. And she's not focused. She can't do her job.
So in order to explain that, the doctor has to write a medical source letter.
Yes, and it has to be detailed. I mean, it's been a point in time in one of my earlier cases, I actually physically accompanied my client to her doctor because they wrote something just very general saying my client is 100% disabled. Well, that doesn't tell the judge anything. All that says is this doctor is supportive of this person filing the claim, but it needs to say what their diagnoses are. It also needs to talk about, or the file needs to reflect any diagnostic testing, which means MRIs, X-rays, CT scans, EMGs, nerve conduction tests, all of these medical terms that I'm only probably recently familiar with. It needs to talk about that, and it also needs to talk about how it impacts someone and what their level of pain is and what they are no longer able to do to really be substantive.
Okay, I'm going to roll back the timeline here a little bit, and we're going to go from the beginning of the application. I'm a claimant, and you're going to be my attorney, and I want you listeners to call in if you have questions. I want to apply for Social Security disability because I have a neck ache, a back ache, and a leg ache. And I come into your office. Mm-hmm. What do I have to do?
Well, first I'm going to ask you, how long have you been experiencing these symptoms?
For about 8 years.
Okay. Have you been to a medical physician to diagnose these symptoms?
I've been to 4 different medical facilities.
Did you ever receive any X-rays?
I had all kinds of X-rays and diagnostic tests.
What did they say?
They told me that I had arthritis because I was getting older.
Okay, let me ask you this first. Are you still working?
No, I stopped working because I hurt too much, and the only thing I do is I go fishing.
Okay. You go fishing. How frequently are you going fishing?
2-3 times a week because it relaxes my neck and my back because I'm not under any stress.
Okay. Well, what I would say is before we can determine if we can take your claim, I'd like to get a copy of your medical record. So I'm going to ask you to sign a release form, and we're going to look through these records together, and I'm going to let you know, honestly, if you have a viable claim.
Okay, so a month has passed. I come back to your office, and the medical records aren't there. What are you going to tell me to do?
I'm going to tell you you need a copy of that medical record, or you need to allow me to obtain a copy of the medical record.
So you're going to send me into my office, my doctor's office, right?
Yes.
And you're going to have me ask the doctor's office to turn over a copy of the records.
Yes, and sometimes doctors will charge. So that is when, if you've given me enough information at the beginning, my office would likely front that cost on your behalf.
Now, you get the medical records and you look at it. Told you the truth.
Yes.
I've got a neck problem, a back problem, and some pain in my leg. Are we going to file an application for benefits?
It depends. It depends on exactly what that medical record says, but it sounds to me as though we have a viable claim. But what I'm going to do first is I'm going to look through the listings, and I'm going to consider other factors, such as your age, your current income, and how you've been surviving in the meantime.
Now I'm going to throw you a curve here. You're going to
Okay.
hate me for it.
No, I won't.
I'm 62.
You're at a fine line because you're right at that retirement age.
But can I receive disability benefits and apply for retirement at the same time?
I believe you can. And what we'll do is do first a look back period. How long, if you've been off of work, you said maybe about 8 years because of your neck and back pain, we could possibly apply for retro benefits. And even though they might only grant that up until the age of 62 or sometime before that when they found that you were disabled, you can receive retroactive benefits.
Now, you know I put in 8 years for a reason, because I would have used up my earning
Credits.
order. Right.
Absolutely.
Okay, I want you to explain the earning credits.
Yes, so it's a very interesting process that I don't know how to calculate myself,
The 20/40 rule.
but I do know that as you're working, you receive credits based on Social Security on what you're entitled to.
Okay, simple way of looking at it is you've got to work 5 out of the last 10 years.
Yes,
And if you work 5 out of the last 10 years, that means that you can apply for Social Security disability. But if you use up those credits in the 5 years and you've been off 8, then you have to prove your disability occurred before the end of last insured status.
yes, and that's where that terminology, date last insured, comes along. We refer to that as DLI. So if your DLI, let's say, is 8 years, let's say it's in 2015, if we can establish that, let's say in 2000 even, that you had these impairments, we can do a look back period. You might be able to establish some time before that based on those 8 years. But if we do an establishment of even 2000 and we look back and we say you had these impairments at that time and they prevented you from doing substantial gainful activity, we can still pursue your claim.
Now, here's an interesting question. Title II is for wage earners, correct?
Correct.
Title 16 is for non-wage earners.
Correct.
That's people who don't have the insured status, correct?
That is correct.
Okay, under the Title II, if you go into the look back period, can I receive retroactive benefits? Can I receive benefits back?
Not from longer than your date of application.
So whenever you apply,
Yes. They are not going to give you anything further back from the time that you dated your application. That's usually about 2 years because that's how long it generally takes to get through the process.
okay, having said that, and I've come in, I've seen you, would you take my case?
I still might take your case because if there's a need, I can still establish that you need Social Security disability benefits based under Title 16.
Now, if I go on Title 16, I understand they receive, what, $750 a month under Title 16?
That's correct. It's not enough to live off of. And that's why I typically don't worry about someone, quote unquote, scamming the system because people who need it, they really need it.
But if I'm on Title 16, can I work part-time?
Yes, you can, up until a certain point. You're not able to get to the amount of substantial gainful activity, which this year, 2018, is about 1180. But to be quite frequent, you should check with the local office. But before we get to working, we need to make sure that we get you Title 16 benefits
Okay,
first.
but for all of our listeners out there who are on Title 16 and want to get a part-time job, you can supplement with a part-time job up to $11,800,
That is correct.
and you will not have a penalty on your benefits.
That is correct.
But if you exceed it, you're going to lose.
Yes, and then that's happened to a few clients. They have exceeded that benefit, and then their claim comes up for review. And there's a readjudication or a reconsideration, as they call it. And at reconsideration, they can remove your benefit if you're exceeding that amount.
So what happens when someone comes into your office? I gave you an example of here I am coming into your office, and how do you make these assessments about people? What do you do?
I talk to my clients. I look at the genuineness factor, but more importantly, I believe people's medical records speak for themselves. I also make sure I prepare my client when we do get to the level of an adjudication before an administrative law judge, that they sound and appear believable. I mean, it's very important because you might be very disabled, but if you have a demeanor or a presentation that doesn't display that, that can hurt your claim.
Okay, we're going to take a break just for a minute. When we come back, I want you to talk about how someone should prepare to come into an attorney's office for the first interview, what they should bring with them, and then we're going to get a little further along and we're going to talk about how should a person prepare to go to a hearing.
Wonderful.
We'll be right back.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
Okay, so I sort of talked about coming into your office the first time. And what do you want me to bring with me when I come into the office to make this a worthwhile visit? And I'm really serious about this because a lot of people say they want to apply for Social Security disability and they walk in a person's office and they're not equipped. And that just causes another, and I pulled my word out here, another interview. I pulled the word out on purpose because it's very frustrating because you've got other people who are waiting to see you. So what happens, or what do you want me to bring in the first interview? What do you need?
In the first interview, I want you to bring an x-ray or an MRI. I want you to bring in some medical records that show me. It's one thing to tell me, or a diagnosis. If it's one thing to tell me I have a back problem, or I have degenerative disc disease, or even bipolar. I want you to talk to me about some of the medications you're on. And I want you to bring me, if possible, either your last pay statement or a tax return so that we can look at income and determine if you're able or eligible to apply. I also want you to talk to me if you have a lot of people don't, but some people invest in short-term disability or long-term disability. I want you to talk to me about that carrier.
Okay, so the importance of bringing in the record is twofold, and let's just deal with this. One, there's a date on the medical records.
Correct.
And why is that date important to you?
That date is important because it helps me to establish when your disability started in the eyes of a judge. You may have been experiencing symptoms, but until a doctor has diagnosed you, it essentially doesn't mean anything.
Would you agree with me that one of the most critical problems, and I use the term critical problems, is that people who apply for Social Security disability do not get professional assistance in filling out the application, and they do not appear to be truthful when they initially apply?
That is the number one problem. And it's because a lot of people think they can do it on their own initially, and they just really don't have the equipment or the tools or know the ins and outs that an attorney would know. A lot of people too, I think they're afraid to go to an attorney in the beginning because they don't understand we're not going to collect anything against you unless you win these benefits. It's essentially a contingency-based case.
Now, what happens after the initial application, that's why I say it's really pivotal to have the correct information at the beginning, is that there's a reviewing process that's going on through the disability office. You know about that.
Absolutely. So at the initial process, that's where I used to work. The disability trainers or examiners actually go through a lot of training, but I'll be honest, it's very much a pipeline system. So they're reviewing your medical record, but they're doing high volumes of lots of people. They're touching at least 50 cases a day. So unless it screams out on that application, you're likely going to be denied the first time, unless it's so glaring.
And there's a rubber stamp right on the form. It says approved, denied. It says denial on there, doesn't it?
Absolutely. And although a physical medical doctor or a psychologist may review the claim, there are some single determination examiners who they review or they have the final say so as whether the claim is approved or denied, and they don't necessarily have medical background.
And what's important about that, that becomes part of the administrative record.
That's correct.
Would you explain what I just said to our audience so they understand it?
Absolutely. So what that means is essentially that's all a part of your application, your DDE, your disability determination explanation. That is one of the first documents that is filed at an appeals level. Oftentimes, a lot of clients don't come to an attorney until they've been denied already on paper by the disability agency or Social Security Administration. But really, if you come to an attorney at the initial process, you might not have to get there.
And the problem is that at the second step, when you appeal, if there's a conflict between the first application and your appeal, ultimately, when you go to a hearing, what's going to happen with the judge?
They're likely going to preclude that first application, or they may weigh that. They have to weigh that in the totality of the circumstances to determine when your disability started, and that could possibly infringe upon the amount of funds that you'll receive back.
Here's the real problem, though, in weighing it. There's a word called credibility.
Absolutely.
Would you explain what happens when the judge has to weigh the original application and the appeal in terms of credibility?
Now they're trying to see if someone is, I don't want to say exaggerating or embellishing, but your credibility is in question, meaning they don't know whether you were non-truthful at the initial step or you just were ignorant and didn't know. But oftentimes they don't give you the leeway, and they have guidelines they have to resonate with, and they don't want all of their decisions to be overturned by an appeals counsel. So they have to weigh your credibility, and that's where also understanding the tools and the language of how to present yourself to the judge and being forthfront and honest are really important.
Okay, so we've got to the second step, and I'm turned down to the second step. What happens after that?
At the second step, if you're turned down, what would happen is do you mean after the appeal or after the second determination?
Second determination.
After the second determination, you have the right to file an appeal before an administrative law judge.
And is that the point in time where the medical source statement becomes really relevant?
Absolutely. You should really have it at the outset, at the initial, if you can, but if not, it's going to be essential at the appeal, because you're going to need something to say that we didn't understand that the problem was as severe and it worsened with time. And that's where your medical source statement really comes in, and it can really win the case.
Now, this is what really is frustrating. If you get a medical source statement when you originally apply, you get turned down. You go to step 2, you get turned down. You get another medical source statement. The doctor's going to say, I already gave you a medical source statement. How important is it to upgrade, and I mean upgrade and continue to upgrade that information as you go along?
It's critical, and you really have to be firm and be kind with your doctor and help them to understand, I know you have a lot of patients to see, but I am trying to qualify for a disability case. This is essentially my livelihood. I need for you to explain very detailed how this impacts me, how my condition has worsened. And oftentimes, a good attorney will assist you in that. They'll say, this is what we need. Same goes for education records when you have some mental disabilities.
Why are the education records so important when it comes to emotional issues?
Oh, it's so important because some people have very severe learning disabilities, or they're actually child claims, and there are some children who have special needs. And you need your education records to show that you're not advancing, that and to really show what your limitations are. because at that point, there in the child case, there are often medical experts or even judges who are determining whether or not a child is really disabled. And because children grow and they change so rapidly, you need that documentation. You also need someone to testify as to what they've observed, what type of behavioral issues they have observed.
In other words, if you've got a child applying for benefits, and we shifted over to children's claims for a minute, you need to have the IEP from school for every year, because that shows how your child is interacting at school,
Correct.
how your child is functioning in many different hemispheres, for lack of a better term, and we'll go into that, to see if that child is eligible for benefits. Now, children's claims are very unique and very special and require special proofs. Just being in special education isn't enough.
Correct. Sometimes having home-based programs. Sometimes there are children or infants with failure to thrive, or they have difficulty maintaining concentration and focus, or interacting with their peers or adults or authority figures.
So all of these factors are relevant for a child, but they're also relevant for an adult, because many adults who apply for benefits, unfortunately, are the product of special education because they had learning, or at least they thought they had learning disabilities. If they grew up in southeastern Michigan, they may not have learning disabilities, may have been just victimized and not given the opportunity to learn to read and write and get an education. So they've been discarded. I hate to use that term, but it's true. And they've been put into special education. They didn't belong there. Consequently, when they apply for benefits, they already have a track record, but they've got to live with what cards have been dealt, and they've got to work with it. So they've got to have all that information when they go into the hearing.
That is correct. And those all help the judge to understand, beyond your testimony alone, what you faced over the few years that you've been applying for disability, and even looking back, if it's a Title II claim, 15 years of your last work environment.
Let me share with you a really interesting story, then we're going to take a break for a minute. About 30 years ago, I represented a man from the Middle East, and I'm not going to say which country because it's not relevant. He was a mechanic in the Middle East. He came to the United States, he was a mechanic, he was injured. He injured his neck. So he's 40 years old, he applies for disability benefits, and he's got a wonderful skill set because he's an auto mechanic. If he could speak English, he wouldn't get benefits, but he did not have the ability to speak English, so he was awarded benefits. On that note, we'll take a break.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
So we started to talk about children's benefits, and I know this is kind of a tangent, but unfortunately, sometimes the whole family has disability issues that have to be dealt with. You have to deal with those, don't you?
Absolutely.
Okay, now you're in a position where you can take on new clients, correct?
Correct.
And how do people reach you?
People should reach me right now. It sounds crazy, but I give everybody my cell phone direct access. So people can call me at 719-1001, or they can email me because I'm in the process of transitioning firms, and I'm actually going to be with a new firm that allows me to take on more clients. And that email address, you should just reach me at Amale, AMALE, .knox, KNOX, .ESQ, @gmail.com.
If you didn't get that, call me and I'll give it to you, 248-335-9266, because she's going to handle child's claims. And the reason it's important is sometimes the family, unfortunately, needs benefits for everybody at different stages. Because it's just hard luck time and they have to get benefits. I've had parents that I've had to handle claims for when they're out of work because they have heart condition, they have children who've got learning disabilities, but the criteria for children is much different.
It is. And I'm just actually getting into child claims, and I'm proud to say I run about 2 weeks ago my first child claim, and it was backdated because the young man had grown and developed and didn't have the failure to thrive anymore. But we were able to get his family some back benefits because he was born at a low birth rate.
Okay, that's one factor that you have to look at, being born at a low birth rate. Another factor that you have to look at is socialization.
Absolutely.
In other words, if you've got a child who doesn't socialize or interact with other children, it's a factor that they look at.
And developmental processes. For instance, if some children can't manipulate or learn different processes, for instance, I had a child who was maybe about 3 years old. He still has not been able to manipulate any silverware, and that didn't happen among his peers.
Okay, so that's one factor that you look at. Another factor would be his ability to walk.
Correct.
Child can't walk because he may walk, but he may be a toe walker because he's got a neurological problem or she's got a neurological problem, and that may be a factor because of stability. These are all issues that you have to look at.
Absolutely, and a child like that would be a fall risk, and they would probably not be able to allow to play with the other children at the same rate, and that could impact their ability to socialize as well.
See the quick thinking over here. That's why you should call her. The fall risk came right out, which is very important to understand because that means that child needs an aide at school to monitor that child on a one-on-one basis in order to function in a learning environment.
Absolutely.
If a child has visual problems, are they eligible for benefits?
Yes, they are. And actually, for adults and children, or at least for adults in Title II, they receive a higher amount of compensation for benefits if you're blind.
Why is that?
I believe that's because they understand that inhibits someone from doing many types of employment, if on a regular basis, from any employment. It's preclusive.
Okay. What about hearing impairments?
Those can be difficult to prove, but that can also really impact the environment in which you can work. For instance, if you have a hearing impairment, you're not able to work at a factory. You'd be unsafe.
Good morning. How are you?
Yes. I'm fine, sir.
Okay, come on,
I just want to
speak.
congratulate the young lady.
Would you repeat?
And her young mentor to our young women.
And excuse me, love, if you could speak up, we want to thank you. We heard you say that, but if you could speak up a little.
I want to say to you, I'm proud of you because you are a mentor to our other young law students, women, I would say.
Let me just tell you thank you, and I'm honored for Mr. Keller to invite me to the show so that I can become more of an integral part of our community and continue to help and give back.
Thank you very much for calling. Now, that was really nice, and you deserve it.
That was very kind.
Now, getting to what we were talking about, which is all about helping other people. So we've got a child, and the child has developmental problems, and the parents, they know their child has developmental problems, but they wait a long time to go in to apply for benefits.
Yes.
And when they do this, haven't you found that the judges kind of look at askance at them and wonder if they're using this as another means of getting money in the household?
Absolutely. And judges can often be skeptical. I understand they have a lot of people they deal with on a regular basis, but I think sometimes it can be important as long as you can show your documentation. It's important to talk about the mental health factor of the parent too, and a parent being in denial and not wanting to come to terms with your child having a disability. So that's why documentation at that point is very critical, and that can help someone understand credibility. But that alone won't do it.
So the interaction of the parent with the school becomes relatively important in terms of getting benefits, because that may be the only source of information that you have.
Correct. And that's why it's really imperative too that the school understands when attorneys contact them, we need that assistance immediately. It's unfortunate because you talked about some children being discarded. And I've actually recently worked on some childhood cases where I've had administrators not get back to me as quickly. And I don't like to threaten people with subpoenas, but it's very important that they help me in this process. All we're trying to do is make sure that children have what it is that they need and the benefits so that they can thrive or their families can help them to continue to get special services.
You know, today there are many more ways of diagnosing medical problems. You know, autism is not just autism. There are autism spectrum disorders, or all kinds of disorders that are in different clusters. And I'm not a neurologist, so I'm not going to go into great detail on that, but only to point out that there are children who are eligible for benefits for a variety of reasons because they function differently and in terms of how they learn and
Yes.
process information. And if you can get them on disability benefits, if they're eligible, there are a number of other services that become available to the children through the state to supplement their educational process so that they can eventually overcome these disabilities and they can become a functional and productive workers, earners, and providers, and not just consumers. That's my big debate in life is, are you a consumer? Are you a provider? And it's more important if you can become a provider. And if you can't become a provider, then we want to help you so that at least you can live as a consumer.
Absolutely. And I think that's so important. It's important that through that process, not to per se label your child, but it's important to help them get the tools. Also, I may shift gears for a little bit. When you have adults with mental disabilities, you become eligible for programs that help you to help take care of your children. Recently, a judge informed me that one of my clients who was having difficulties with her children could qualify for some services in Wayne County with the Mental Health Authority. I actually used to work with a gentleman named Madasser, who I believe helps with that department, if it's not over that department. And that really opened my eyes to understanding that there are case workers who will help you get a caregiver. It'll give you an opportunity to do some things around the house or maybe take a mental break, and they'll come and take the children for you. So there are lots of services at the state level and county level that you may qualify for, but it's about establishing those resources and your case through disability.
And what's important to understand is if you establish a Title II case where you were a wage earner and you've got minor children, your children can receive benefits.
Yes.
It may open up grants for them when they want to go to college and other programs that would not necessarily be open to them. Can I receive veterans benefits and Social Security disability benefits at the same time?
Yes, you can. Actually, I've had quite a few clients who have been 80% awarded disability by veterans or 100%, actually any percent, and you can receive them concurrently.
Now, if I receive workers' compensation benefits, look at her, she knows I'm going to do this to her. If I receive workers' compensation benefits, can I receive Social Security disability benefits at the same time?
You know, I've had a lot of judges ask me about that. They want to know whether you receive it or not. They look at that as a part of your income.
Okay. And what's really interesting, if you work for the United States government and you receive postal benefits, if you're a postal worker and you're disabled, you can't double up and receive Social Security at the same time. You can only receive one or the other. So there's a maximum. The only individuals, and if you're a veteran out there, you know a veteran or somebody who's applying for veterans benefits, and you're not able to work, you should apply for Social Security because you can receive both benefits at the same time. And you're justly entitled to receive it because of the service you've given our country.
Absolutely. And let's just take this as a moment too. I know what you would want to do, and to thank all of our veterans. My dad is a Vietnam veteran, and he's actually on veterans disability. The firm that I'm transitioning from are wonderful people, and they are Champagne and Associates, and they have specialists. I am not, but they have specialists who only focus in on veterans claims.
Right, in order to do that, attorney has to practice a number of years and be certified by the Veterans Administration.
That's correct.
Take an examination, pass the exam, go through a rigorous process.
Yes, and those benefits can take the process can take a little bit longer even than Social Security. It can be a little bit lengthy, but it's about the ultimate goal of helping someone who needs the help.
Yeah, the whole purpose of the show today is to illustrate to you the various ways which you can receive disability benefits. I know we flip-flop between children's benefits, Title II, Title 16. We're going to take a break for a minute. We'll be back. Hopefully you'll start calling in with questions.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
We're back. Good morning. I've got a caller here.
Hey, good morning. How are you today?
We're doing great. How about you?
All right. Listen, I've got a question. I was a firefighter for 20 years, and we did pay in Social Security fund. Now, disabled, tired, I'm 63, but I'm getting less than $500 a month in benefits. And I don't have to tell you, that's not getting it. But if I make $5, they want to deduct an extra $5. You know, and I'm wondering if there's any way to like reopen this or do something. Because I was off for years before they finally opened my case. Then they say, okay, well, you got some money between, but I don't know. But they deducting money every month to pay back the benefits that they gave me at first. Yeah, it's really just a major mess. But ultimately, it's like this $500 is not worth it. And my question is there anything I can do to like get this thing reopened and reevaluated with somebody that's actually trying to straighten it out, or am I just done for?
we talked about it a little earlier. Can you perform any kind of work?
Okay, I got to be turned off.
Okay. Okay, can you perform any kind of work? If you can perform any kind of work, or you can even get hired in a place like Kroger's where they take people with special needs and give them jobs, you work part-time there, you can supplement your income up to $11,800 a year and not lose your benefits.
That is correct. I heard, it was hard to hear you, but I understand what you're saying, and you're talking, I think you talked a little bit too about an overpayment. Was that correct? And sometimes those are difficult. A lot of people consult an attorney, but unfortunately, the way that many government systems are set up, sometimes that they overpay, and so they require you to pay back any overpayment. The same is true as of Medicaid.
So essentially what you have to do is you have to go into an attorney's office and let the attorney investigate the case to see what they can do to help you. And I'll explain to you one of the issues that you can deal with that hasn't been addressed. It's called hardship. There's a forgiveness and a Social Security process for hardship. However, when you go in and ask to forgive the past due benefit, you're going to have to go to a hearing, and you're going to have to establish the lack of capacity to pay back, or you don't own or possess assets that can be converted into cash to pay back the overpayment. If you're willing to go through the hardship process, give me a call at 248-335-9266, and I'll help you through it. I'm not going to get paid $1 for doing it. I'm not looking for $1. I'm not looking for a penny. I'm looking to make you a little more comfortable on your days as they go by.
That's correct, and that's one of the reasons I'm very honored to be here today. Barry is an amazing gentleman, and he does a lot of help in our local community. He actually shared with me this morning that he participates with a group in Brightmoor to make sure that people are fed.
Yeah, we have to do this, but it's not about me, it's about helping you. So if you got people out there who've got these problems, give us a call at 248-335-9266. All we want to do is educate you, inform you, and serve you and give you the information. Now, getting back to the children's issue, because it's a big issue, the longer you wait to apply for children's benefits, the harder it is to get, correct?
Absolutely, because the judge is going to ask you, why didn't you assess this at the beginning, or why didn't you get your child help? So throughout the process, if you have a child with a disability, you need to be documenting that, even if it takes you a little bit longer to apply. And you need to do that through your schools, and you need to do that through their physicians, as well as any social programs that they are involved in, or any type of special needs programs. That's a very important process. So don't wait on that.
Now, if you have a child out there who unfortunately was born as a result of birthing trauma, and you file a lawsuit and you recover, you can still get your child benefits and Medicaid and shield the recovery for the special needs that your child has. Because it's really expensive to raise a child with special needs.
Absolutely.
And that it's important to consider all of these factors. That's why we're here, to give you information and to help you. What do you have to say to our seniors about getting benefits?
Seniors, it's important that you apply. A lot of times, I know you guys are struggling. You're already on a fixed income. There are Title 16 benefits available for you. And it's not based on your work credits, but it's based on your need.
Now, suppose I have a pension, though. I can't apply for Title 16, can I?
No, well, I believe it depends on how much your pension is. But if it's a substantial amount, you're not able to.
Okay, so if it's over $500 a month?
I think if that's not substantial gainful activity. Right now, substantial gainful activity would be about $11.80 a month. So if your pension exceeds that, you're not going to qualify, because they're going to consider that income. But if it's under that and you still have a need, you can apply.
Now, with respect to government assistance, do they deduct food stamps for my benefits if I'm applying for Title 16 SSI benefits?
I don't believe so, but that is a part of the process that the judge will ask. They'll ask if you're receiving Medicaid and or food stamps.
Okay, and why is that so important to the judge?
They want to know how you're supporting yourself, how are you surviving, and it also helps establish that you are a need-based person.
You know, one of the most difficult tasks we really didn't address today is that a person applies for disability, but they're a caregiver for their parents. They're disabled, and mom and dad are maybe in their late 70s, early 80s, and the caregiver wants to apply for benefits because the caregiver can't work. That's a real tough case, isn't it?
It's an exceptionally tough case, and really, what you tell your doctors, everything they repeated in your medical record. But let's talk about what caregiver means to different people, right? Some people think checking in on their parents is providing care or fixing a couple meals. But if they have other people assisting who are bathing their parents or who are doing the errand running for their parents, they might not really be a caregiver.
But if they're in the house and they're doing the laundry and they're doing the dishes and they're doing the cooking, then they're capable of performing substantial gainful activity.
Correct. And so they may count that as work credits, but that's still seen as SGA, so that would likely be a step one denial because you're not disabled unless you have a severe impairment or combination of impairments that last 12 months or longer. And quite frankly, even if you do, if you're still working, the judge is not going to consider you disabled.
Last week I had a trial and I had to ask a woman the following question. Are you capable of preparing your own meals? Because this is a very important issue. She looked at me and she said, if getting a loaf of bread and a package of bologna is preparing my meals, I'm capable. And that was her level of preparation. That's all she could do. So don't be afraid to admit what you can't do.
But to show credibility, you also want to say what you can do. It's also important if anyone has a substance abuse issue, if you've shared that with your doctor, that you're honest about it. But one of the ways to overcome that is to talk about any recovery, any rehab. And of course, your attorney will cite to an argument depending on what your actual impairment is. If it's unrelated to any alcohol or drug abuse, that's not going to necessarily kill your case.
Okay, I'm going to translate this. She said it really nice, and that's the way it's written in the law. If you're addicted, but that isn't the basis of your disability, you can still receive benefits. So if you're habituated or addicted and you've got 4 fractured vertebrae and you walk with crutches as your only means of walking and ambulating, you're still entitled to make a claim for benefits.
Absolutely.
And I just gave it to you hardcore because there's no other way of explaining it.
That's correct, and you really helped me. In the past, I've had a client before who he had a brain surgery. He had brain cancer, and maybe his medical record noted that he'd smoked some marijuana at one point of his time, but the judge agreed with me that based on the legal argument, that was not the cause of his brain cancer, and he still was able to apply or receive benefits.
The most important part of any case is truthfulness, because there's a credibility test. The judges in administrative hearings always are required to refer to credibility. And it's very difficult to defend a credibility issue if someone is not truthful. But if you're totally truthful in whatever you say, it's much easier in the process of dealing with it. Would you agree?
I would agree. And they actually look at a lot of forms that they have you fill out in the beginning of the process. I've had a judge cite me to a work form or to a residual functional capacity form or saying what your activity level is. So if you say on this form, I'm walking 2 miles a day, but then later you get to the hearing, you say I can't walk at all, you have to explain, and your medical records will have to explain how you've worsened. But they might take you back to that form and say, 2 years ago, you said you were walking 2 blocks a day. What's changed? And if there's been no change, they'll be able to pick up on that untruthfulness very quickly.
Mel, you're going to get the last word. Tell people how to get a hold of you.
Thank you. So you can get a hold of me again on my cell phone at 248-719-1001. I'll soon be starting with milder disability, and we're able to take cases from start to finish. But for some cases, I would definitely say, please call our host, because Attorney Keller is more specialized in the difficult claims. However, you can also reach me at amale, AMALE, .knox, KNOX, .esq@gmail.com.
And thanks for listening. This show is going to be repeated during the week. You won't be able to call us directly on the show, but you can call us if you have got questions. Thank you.